All right, folks, I'm going to call this meeting to order. We do have a couple senators missing who are probably enjoying some lunch before they make their way over to the committee, which I did invite them to do. So which will work out just fine because before we actually call roll and move into the legislation, I'm just going to have some opening remarks to and about the committee. The first remark I will make is the appointment of my vice chairman, which will be Senator Crago. So in my stead, Senator Crago can take over. Next are just some opening decorum matters. As we begin our meeting, I'll remind everyone about the committee's rules of decorum. Copies of the decorum rules are located within the hard copies of the agenda and are available for view on the legislative website on a page for this meeting. Let's see what else. We will, of course, as a body, treat those who are testifying before us with respect and will be courteous. We ask the same thing from the public, that when you testify that you are respectful of the senators and courteous as well. Our meetings are open to discussion for all viewpoints, and the rules of decorum are in place to ensure that everyone can express their opinions free from abusive or distracting behavior. Take a moment to read through all the listed decorum rules. One of the big ones I think that I see a lot with testimony, and this actually happens less with new testimony and more with people who have testified for years, is to remember to address the chairman. It can become very casual quickly, and engaging in a conversation with a senator, and you quickly forget that you should be directing your comments to the chairman. So I will just remind everyone that that's important to our rules of decorum. Of course, speakers should avoid personal criticism, ridicule, or name calling or directed at anyone else in attendance at the meeting, which includes comments of a personal nature directed at other speakers, the audience members, or members of the committee. For audience members, we expect you will refrain from any behavior that disrupts the orderly conduct of the meeting. Specifically, the rules prohibit speaking out when another person is talking, carrying on loud or distracting side conversations, and shouting, clapping, or booing in response to a speaker's comments. Our general guideline is simply that everyone conducts themselves in a civil and respectful manner at all times during the meeting. And with that, we'll go ahead and take the roll, and then we'll get started.
Senator Crago?
Here.
Senator Crum?
Here.
Senator Hicks?
Excused.
Senator Kolb?
Present.
Chairman Olson?
Here.
You have a quorum.
Thanks. And committee, I forgot to mention one more thing. What LSO has asked us to do when we are casting our votes is to light up your mic, so that those out in the world who are viewing us through Zoom can actually hear the vote. So that's something I know that we're not totally used to, so we have to remind ourselves, and I'll try to remind you as well when we get to that stage. So we are looking at 4 pieces of legislation today. These are all bills that were crafted by the Joint Judiciary Committee during the interim. I believe the only returning member is Senator Crago, who was on the House Judiciary, right? So we're going to rely on Senator Crago to help walk us through some of these bills, because the rest of us, I was the chairman of corporations on the House side, so these are all brand new to me. So we will rely on you as heavily as we can, Senator Crago. The first Senate file for our consideration is Senate File number 6, Residential Property Removal of Unlawful Occupant. This is legislation, Senator Anderson. Is this legislation that you brought forward to the committee?
Yes.
Do you have any opening remarks that you want to make about this legislation, or do you want to just wait for general public comment? Maybe give us a little background of how this bill came to our committee.
Thank you, Mr. Chairman. I'd love to. I had a constituent came to me and had a big problem with 4 or 5 bruisers in one of her houses that she was building. And she got out of the situation quite nicely, but came and said she went through the process with the legal entities to try to get those guys kicked out, found out it had to be a civil case, and she wanted to make it a criminal case. And so that's what this bill is trying to do, is make it a criminal case. We went to the LSO and talked to them about patterning that after what Florida had done, and Florida had done a good job with making it a criminal case. So we took the Florida bill and turned it into a Wyoming bill by a few changes that the LSO made on it. And that's what you have before you. It is only for residential. It is not for business and industrial. And after we got into this, and I think you'll hear from them today, the statewide realtors found out that there was plenty of this going on all over the state. And then I was contacted by industrial and found out that there was a lot of it going on for industry and commerce, but we need a separate bill for that. We didn't try to incorporate that into this bill. This is strictly a squatter's bill for residential, and it's not for somebody who is renting from the landowner. It's from somebody who just moved in with no permission, no anything. For the people that are renters and then don't pay the rent, there's other avenues for them to kick somebody out. But this is for somebody who doesn't pay any rent, is just in there squatting. And we think we'll see a lot more of that in the southern Wyoming in the future. But right now, it's all over the state. Thank you.
Very good. Thank you, Senator
Any
Anderson.
questions?
Committee, any questions for the senator? No? Okay. Senator Crago, anything else on the introduction of this Senate file that you think we should touch on before we jump into comment?
So just a little bit, not necessarily about the bill, Mr. Chairman, but just sort of its interface with our current process, which is forcible entry and detainer. Our whole intent was to stay out of that realm so that we're not, there's not, overlap between the two types of remedies. This is involving law enforcement and getting action more quickly than what would happen through the forcible entry and detainer process. I'm happy to answer any questions that the committee might have about the bill, and can do whatever you need me to do as far as explaining it, Mr. Chairman.
Committee, any questions about the legislation for Senator Crago? No? Okay, and just for the public listening, just briefly, the bill, we've talked about it, how the bill creates a process for property owners to seek assistance from law enforcement to remove someone who is unlawfully and unauthorized occupant of their property. It does establish fees and liability and civil remedies. And as Senator Anderson pointed out, it does create a criminal offense, which is a felony. And a felony punishable by imprisonment for not more than 10 years, a fine of not more than $10,000. This is on page 11 and going over to page 12. That is if the person unlawfully detains, occupies, or trespasses upon a residential dwelling, who knowingly defaces, injures, or destroys property in or on the residential dwelling, regardless of the cost of restoring the injured property for the value of the property if destroyed. And then I think there's a misdemeanor provision, isn't there, Senator Crago?
Mr. Chairman, so there's on page 10, there's a provision called unlawful advertising or providing false documents for fraudulently conveying or leasing real property, which when we get into another bill we have on the agenda for today, we'll have to discuss this because I think there's some overlap there and some potential for confusion. The whole point of this was to provide some sort of remedy for law enforcement. If someone shows up and asks for proof of ownership or the right to be in a particular property, and this is happening around the state. We did have testimony about this in particular during the interim work where folks are, writing up false documents, handing it to law enforcement, particularly in the FED process, and then providing that not only to law enforcement, but eventually some of them to the court system, or maybe they just provide it to law enforcement by themselves, the statutory allotted time under the FED process, and then skip town, go to a different place, start it all over with the fake lease, and there's really nothing we can do about that, and that was the attempt to fix that particular problem.
Which is primarily is addressed by that other legislation.
It could be, Mr. Chairman. The other one is a felony, and it's a much, the language is a little bit different, and it's more closely aligned with the forgery statutes, to be honest. And so it's a different penalty. It's a felony. It's a much higher consequence as far as fines and jail time.
Other than what Senator Anderson brought forward as a issue with his constituency, was there any other testimony in the committee from any residential property owners who experienced this in Wyoming?
There was a little bit. The realtors were also in attendance, and there was some discussion from their group regarding this particular problem.
Great. Okay, we'll hear from them. With that, let's go ahead and move into public comment. I'm not sure if we have any state agencies that would want to testify on this legislation. No, if not, we'll just go into general public comment. We'll welcome the realtors.
Thank you, Mr. Chairman. I'm Lori Urbakite with the Wyoming Realtors, and indeed we did testify on this. And when Senator Anderson first spoke to me about it, and it was a realtor member in Casper, and it was her own personal property. And the tenant had moved out and had told her he had moved out, and she had then gone to the house to see what kind of cleaning it needed to be done or any of that kind of maintenance work. And as she turned the key in the lock and opened the door, here are four big guys standing there, and she's not a big person. And they're saying, what are you doing in my house? And she goes, no, what are you doing in my house? And so it was a very tense situation. She was by herself. And so she did go back the next day with someone much larger and stronger than her, and they had indeed left. So it turned out well. But I did, at that time, I sent out an email to all of our members, and I did hear from members all over the state of Wyoming. One was in Park County, and this was a young agent. She'd just gotten her license, and she was sent by her broker to a foreclosure home. The house had been foreclosed on by the bank, and the redemption period was up, and the previous owners were gone, supposedly. And she got there, and there was a squatter. And she was young and new and terrified. And they had done substantial damage to the property. So again, and I've been asked many times, why doesn't the trespass laws cover this? The issue that we are hearing is that as soon as that person insinuates that they have a legal right to be there, then the police are going to step back and say, this is a civil matter, take it through forcible entry and detainer, which can take up to 6 months to get done. I know, I've been through it and it was painful, but so we're very supportive of the bill. We have one suggestion, and that is on page 4. I think it is on page 4. Let me scroll. And it talks about one of the things that the owner has to do is sign an affidavit, and part of it, the requirement is the date on which the residential dwelling was acquired by the owner. In the original version, it said purchased, and I convinced the committee that that was not accurate, because what if it was inherited? It wouldn't have been purchased. But then, as I did more research, and I spent 2 hours on this yesterday afternoon, looking at how you find out when it was purchased. So I own a house in Riverton, and so I went to the Fremont County website, and if you go on their mapping system, it's not easily attainable elsewhere, but you can go on their mapping and you put in the address and it'll pull it up, and it actually shows over here in the corner in very little print, but nonetheless it's there, that I purchased that home July 11th in 2000. And that was accurate. So then I went to a rental property we have in Casper, and it was, Natrona counties is much more difficult to get to the mapping and to get to that information, but I finally found it, and it was blank. There was no address on it. I went to the house that we currently live in, and I found it, and it showed the day that we put it into a trust, family trust. My husband has Alzheimer's, and there is no way I can find out when he actually acquired that property. There's just no way. So I don't understand the need for that language, quite frankly. And I'm used to doing looking at those mapping things because I was a practicing real estate broker for many years. I don't think your normal citizen's gonna understand where to go to find that information. So I don't know that it matters when they acquired it. I really don't think it matters. The fact is that they are the current legal owners. That should be enough. So I would ask that that be deleted. But other than that, Mr. Chairman, we really appreciate the effort. It is happening all over the state. And we appreciate your consideration. I'd be happy to answer any questions.
Committee, any questions for Ms. Urbakite? No? Okay, yeah, I agree with you. I wasn't there at the creation of the bill, so I don't know what the purpose would be for having to declare the date in which you acquired the property. In talking with Senator Crago about it, it's possible that it could become relevant if you recently acquired it, very recently, kind of like the scenario of your friend, your realtor friend, who had acquired it, and then maybe there's confusion over a lease that traveled with the conveyance of the property or something of that nature. But other than that, I agree, I don't see a purpose for it.
Mr. Chairman, in the language of the bill, it also requires that you sign an affidavit that they are not a current tenant or a previous tenant. I guess you could lie, but we are not trying to get around forceful entry detainer for carryover leaseholds or rentals that the rent or the lease is expired and now it's on a month to month. We have several of those personally. And in the instance of the testimony from the realtor in Casper, she'd owned that property for many, many years. She was just going in to see if it needed rehabbed or cleaned up.
I see.
Yeah.
Okay. Senator Kolb?
Thank you, Mr. Chairman. Ms. Urbakite, when it comes to finding out the owner of said property, is it possible to go down to the county courthouse and find that data, or is that not, you can't do that? I mean, I'm confused about how you couldn't find that out.
Mr. Chairman, you can easily go to the treasurer's website, county treasurer's website, and look up who owns the property very easily. That is not a problem, but it does not say the date it was acquired.
Senator Kolb?
Thank you, Mr. Chairman. Yeah, my point would be is just go to the courthouse. Wouldn't they have the date there available? I realize it might not be available online, but wouldn't it be available at the courthouse I realize it's probably more trouble, but is it not there? I guess is my question.
Mr. Chairman, I believe they'd have to go to the assessor's, or not, the clerk's office and have the clerk research the deeds back to when that original deed was filed.
Yeah, you'd have to find the original deed, and the deed would have a date of the conveyance. And I think the problem Ms. Urbakite was pointing out was if there were some transfers to yourself that occurred, maybe you added a spouse to the deed, or you put it in a trust, or you put it in an LLC, all these, different possibilities of things that you could do. You would have to go back to the original deed to know, but yeah, you could find it. I agree with that.
Mr. Chairman.
The average person probably wouldn't know what to do, but.
It's possible.
Senator Crum.
Yeah, just a quick question, and you're right, I did look up here that it doesn't show the date right on the electronic site, and we all agree that you can find it if you went to the courthouse and searched the records. But my question for you is, what would happen if this incident took place, let's say, this coming weekend on a Friday evening, and the courthouse then won't open up because of the 3-day holiday till Tuesday to find that information? You got 3 days with people living in your house. Would that be a problem?
Mr. Chairman, I would think that would be a huge problem. Absolutely.
Other
Thank you,
questions?
Mr. Chairman.
Yeah, other questions for Ms. Urbacate? Senator Hicks.
Yeah, Mr. Chairman, my apologies for running just a little bit late, and so I didn't hear an explanation of the bill, but a couple questions, and I don't know if Ms. Urbacite is the one to answer these questions. But when I look at page 3 and Romanet A, and it says the owner or authorized agent may request law enforcement in the county for the immediate removal of a person. So whose duty is it to verify ownership? Is that then become a duty incumbent on law enforcement to verify that the person requesting that is actually the owner? So that's the first question. And you know, how they go about doing that is part of this other. I'm just wondering whose duty and responsibility, once that request is made, to make sure that there is actual verification.
Mr. Chairman, so the process, as I understand it, is that the owner fills out this affidavit, takes it to the police station if they're in town, takes it to the sheriff's department if they're out in the county. And it originally said, I think it originally said sheriff's department, but then we changed it to law enforcement. So it can go to the municipality, to the city PD. They would verify that indeed that person is the owner, and they can do it quickly and easily online through the treasurer's office. They can say, yep, your name's on the tax deed, yep, or your name's on the tax record, your name's signed here, absolutely.
Follow up?
Senator Hicks.
So, and I think that's probably accurate as long as they've got access to the internet and the records are up. So, you know, assuming that everything's working the way it's supposed to, which I guess coming from rural Wyoming, that doesn't necessarily always happen. And so I just want to make sure. So let's follow up with that.
Well, and
So
just
once we can make a
Senator
determination.
Hicks, just to, comment on that, even in my county, in an urban setting, it's not, that information is not immediately available. I transfer property daily. Does law enforcement just accept the affidavit? Or do they actually have a duty to verify everything in the affidavit is true?
Mr. Chairman, if you go to page 6, I mean, there is a duty put upon law enforcement to verify that the complainant is the actual owner. And if they're unable to verify that, then they cannot take any further steps under this particular proposed law.
So, Mr. Chairman, and
Yes.
thanks for pointing that out, but then it gets down to the other duties that we put on there is, so if he can verify the owner, right? How does he verify that there's any known pending litigation associated with the property? Is that covered someplace else? Because if you go down to page 3, line 21, Romanet 3, these are the conditions are met. It's got to verify the owner, the residential dwellings owner is agent, but then you have these other duties that we're putting on law enforcement. How would a law enforcement agency, once they've verified ownership, then be able to verify that there was no known pending litigation?
Senator Hicks, I don't think they have to verify everything in the affidavit. On page 6, subsection C specifies what law enforcement has to verify, which is record ownership. But I don't see anything saying that they have to verify everything in the affidavit.
Okay, well, that's what I was looking for.
Yeah.
Thank you, Mr. Chairman.
Senator Craigo?
Oh, that's exactly what I was gonna say, Mr. Chairman.
All right.
is That's the only thing we've put upon law enforcement at the initial stage. And then there's a civil remedy if you go further back in the proposed statute, that if the complainant files a false action, they have, there's a civil remedy for the person who's occupying the home.
Okay. Did you have any additional questions,
No,
Senator
thank you,
Hicks?
Mr. Chairman.
Any other questions for Ms. Urbacite?
Mr. Chairman, I would
Yes,
just
please.
say in response to your comment about how long it takes to show up on the assessors. So if I'd bought the property 6 months ago, I would probably still know where my recorded deed is, and I could take that deed to the law enforcement officer to prove that I do own
Right.
the property. So,
Yeah, I would think that would be the best way for anyone to do it. They should just have a copy of their deed. Yeah,
absolutely. Thank you, Mr. Chairman.
okay, thank you, Ms. Urbacite. Other testimony on this Senate file? Welcome.
Thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, which is a Wyoming Association of Sheriffs and Chiefs of Police. We had some pretty heavy involvement in this in interim testimony, and we're able to get the language, I guess, adjusted to cover any concerns that law enforcement really had. But the question that came up earlier this morning or today was on page 4, that Romanet 2, the date on which the residential dwelling was acquired by the owner. It's my belief that that language was in there initially to try and determine if I bought this house on August 1st and the previous tenant had, or previous owner had rented it to someone, there's probably tenancy rights to that person that's living there as it changes hands to the next person. So while I don't know that the date on which the residential dwelling was acquired by the owner is needed for this, I would maybe suggest that there's language that the owner or the person filing this paperwork attests to no knowledge or advisement of a previous owner providing tenancy to people in question. And by no means am I a lawyer or somebody that should be writing statute, but however the wording would just change that Romanet 2 to cover for previous tenant rights that may exist.
So you don't think it's enough that they just testify that there's no person, current or former tenant of the, because they have to attest to that there's no current or former tenant in writing or oral?
Yes, Mr. Chairman. I think that a new owner of a property might not know that the previous owner had rented it or leased it or had a handshake agreement with someone to stay there until the property sold. So I don't know. Maybe somebody else could answer that more completely.
Okay. Did you have any other testimony, Mr. Thompson?
So, Mr. Chairman, just some of the questions that came up about the using of the county GIS or mapping system for tax purposes. One thing that I would note is I recently was looking on there in my home county, and I realized that a property owner name was removed at request of the owner. So I think we're looking at 23 different counties that run that program differently. And to some extent, there's trusts and withholding of names of ownership. So the 5 o'clock on Friday afternoon report to law enforcement doesn't necessarily mean that immediate action can be taken. Now, that doesn't mean that law enforcement's not going to go, but if they show up and investigate what could be a general trespassing as we know it today, if someone is illegally in that residence, law enforcement is empowered to remove them and or cite or arrest for trespassing. Where it comes into question and this bill hopes to address is those claims from people that there's some sort of tenancy right or legal ability to be there. So I'm just cautioning that there could be those circumstances where immediate action by law enforcement, even if this bill passes, may not be available based on law enforcement's ability to corroborate the information as required in the bill. And Mr. Chairman, I don't have anything else, but I'd be, excuse me, happy to answer any questions.
Okay. Thank you for your testimony. Any questions for Mr. Thompson? All right, very helpful. Thank you. Mr. Moline.
Thank you, Mr. Chairman. Excuse me. Brett Moline, Wyoming Farm Bureau Federation. This is policy to support this type of legislation just passed my organization in November. So it's becoming more of an issue. Not that I know of any members that have had this happen to it, but my members are aware of it. It's important to them. So sitting in support of this legislation, with that, that's all I got to say, trying to be uncharacteristically brief. So I would take any questions you or the committee may have. I don't like the giggling that I hear in the background.
Well, that was very brief, which is
But you know where I'm coming from, so.
Yes,
2 thumbs up on this bill.
very good. Any questions for Mr. Moline? Senator Hicks?
Mr. Chairman, if we get done with Mr. Moline, I do have a question for Mr. Thompson.
All right, I think we're done with you, Mr. Moline. Mr. Thompson, we've got a question for you.
So, Mr. Chairman, Mr. Thompson, the question arises on page 8, and it's basically line 10 through 12, where it says, law enforcement may charge a reasonable hourly rate that the owner shall pay to law enforcement. Can you walk through to me procedurally, how does because we're talking about a lot of different jurisdictions, 96 municipalities, 23 counties. With your organization, have you talked about any uniformity on how that would be enforced? What's a determination of a reasonable hourly rate, or whether the entities that you represent would even initially start looking at sending bills out to landowners for performance of their duty to remove these folks? What was the discussion within your association?
Mr. Thompson?
Mr. Chairman, to answer the senator's question, could you refresh the place in the bill? Because I had
It's
to find my
page-
computer.
Page 8, or sorry, yeah, page 8, line 10 through 12.
Mr. Chairman, there's kind of an accepted, I don't know if it's a practice, but it occurs in Wyoming right now that judges will order law enforcement to do what we call a civil standby, just to make sure that opposing parties don't get physical or otherwise create any further crimes. There's some instances of the courts ordering reasonable payment for such things, especially involving civil-only trials and not criminal. So that concept somewhat exists in Wyoming. And it's my understanding that an hourly rate for a deputy or a police officer is something that's usually charged. If it is charged, it's not always charged. And the biggest thing is the reason why I believe that exists is because some people would request a law enforcement officer to stand by while they move their property out of the house, which could take 3 days. So in order to limit that extensive amount of time that law enforcement is just standing by, there's sometimes a cost associated with it to diminish that to a 4-hour period or a 2-hour period or something that is more manageable. Our organization has not spoken about a standard across the state. I don't know that we could get to that when you look at the salary ranging in Teton County to Niobrara County is a vast difference. But typically you would see an hourly rate or an overtime hourly rate being attributed in a case like this.
Mr. Chairman,
Yes.
if I can follow up maybe, and I believe Senator Craigo may have been on the interim committee when this was taken. So first, when you get through those cost allocations like you talked about, that's already kind of out there, how do you attribute those costs? And so that's for my edification, but also maybe from the committees, I wonder why we're charging the owner the cost to get rid of somebody that's violating the new statutes. And it kind of seems like it's reversed to me. Usually, perpetrators pay fees, fines, and that stuff. And here in the performance of a legal duty, now we're saying you got to pay for that service. So a little on those two issues, if you could help me out.
Mr. Thompson?
Yeah, Mr. Chairman, I'm actually not familiar with why that language is in there. It could be from, I don't know. But I do understand that does further penalize a victim of a crime, essentially. And, short of court orders or other allowances in statute, like the cost for process service, there's a cost with process service, even if you're the victim of a tenant that doesn't leave when they're supposed to, still costs you $50 to have the sheriff's office deliver that paperwork. So.
Right. And I don't think you need a statutory provision to give you a right of action against the squatter, but you could bring a small claims action against the squatter, I assume, and try to recover some of your fee. Senator Craigo?
And I'm trying to vaguely remember when we did talk about this, and I think we actually changed the language, Mr. Thompson, maybe between the two of us we can remember, but I think originally it had the service fee. There was some language regarding service fee. So the service of process fee was originally in the bill, and I think we took it out and changed it to this because there was no uniformity even for that. And it didn't really fit because they weren't at that point serving a notice anymore. I don't know if it's even necessary, but that's, I mean, I don't necessarily disagree with you about that. And so it might be a good amendment to this bill to clean that up. But thinking back, I think there was some language in there regarding the service fee, which varies across a lot of the counties, and also, it's coming to me again. I think part of it was also because under the statute, municipalities can't charge a service fee. But the sheriff's office can, and so that's why we changed it to this language, so that if it was your local PD versus your local SO doing the work, that they could, I guess, recoup some of their costs in doing the standby. I think if I remember correctly, maybe that's what it was, because originally it only applied to the SO, the sheriff's departments across the counties. Did not apply to the municipalities or any other local law enforcement. And so this language was put in there so that it could have applied to all of them. Do I think it's needed? Probably not.
All right. Any other questions for Mr. Thompson? Yes, Senator Kolb.
Thank you, Chairman. Generally speaking, I have a question about when you start charging. I mean, obviously, there's that debate about people pay taxes and the counties, or whoever's in the sheriff's office is funded by the county. And when do you make that determination when it's onerous upon, I guess, the law enforcement agency on what they're doing? I mean, there's going to be a point, I assume, like if it was for an hour or two, I don't know what the number is, but is there a determination of a reasonable time period that you'd expect to be providing a public service as law enforcement goes? Thank you, Mr. Chairman.
Mr. Thompson.
Yeah, Mr. Chairman, I actually don't have personal experience with formulating a charge for things that aren't already established in statute. But I think if you were looking for a number, I think a 2-hour limit would be a reasonable expectation for service to a specific call, where then it starts to negatively impact the ability to provide other services throughout the county after that period.
Any other questions for Mr. Thompson? All right, thank you for your testimony. Mr. Carenti, welcome.
Thank you, Mr. Chairman. Joey Carenti. I'm the Executive Director of Rural Wyoming Matters. We're an informational and advocacy group throughout rural Wyoming. I heard a lot of comments that are concerning. I do believe that there's already a process in criminal proceedings for a restitution hearing. So if any charge by the PD or the SO, they could pursue, I guess at that point would be a suspect or the person on trial directly instead of the property owner. That's a concern because in rural Wyoming, any amount of money is a lot of money, especially to somebody who is already dealing with, I'm trying to make money, renting out my property, things are going wrong. Maybe a little more consideration into the language of during a restitution hearing of the prosecution of the crime. The police department or the agency would recoup that by court order. I heard earlier the time frame between transferring title, having your title and deed, the GIS. My concern is not that it would have to happen immediately and someone would need to get to the courthouse on Friday. My concern is that no matter what day of the week it is, if the courthouse is open across rural Wyoming, sometimes that's already a 3.5-hour drive to get to the lands office. Hopefully they're not too busy and you can get it done that day. I think having that date of ownership, if you don't have your documents, it's going to encumber a lot of rural complainants in the future. I also heard there was concern about individuals who chose or requested that their name be removed from that website. That's on the owner. If they're going to file an affidavit and complaint and can't prove that they own the property because they asked to be removed from that system, their complaint might take a little longer. And another concern I heard about is if there's a current tenant or a previous tenant, and maybe the first speaker who testified earlier could answer this better, but I believe that's part of the process of disclosure during the transfer of property, whether you have a tenant there or not. So I think a lot of these things, they're good to talk about, but really when it comes down to it, having the language in the bill that says you need to be able to prove the date of purchase if you don't have your deed in your hand. And I would say anybody who's involved, from the assessor through lawyers and real estate agents, always tell your tenants or your customers, keep that until you see it here and keep it handy. It's going to be an encumbrance to people who face this situation in rural Wyoming. I know if I lived next door to my senator and we had this problem, half the year I would only have one route to get to the county courthouse. Half of it's an unpaved road. It goes into another county and would take hours to get there if the weather's good. So with that, Mr. Chairman, I stand for any questions.
Questions for Mr. Carenti? All right, thank you. Other testimony on this Senate file? We have testimony online, Mark Miller and Julie Gleam. Whoever's ready, go ahead and let them in. Okay. Mark, welcome. Go ahead and announce your name, and if you ever represent an organization, what organization that is, and then tell us what you want us to hear.
Sure. Good afternoon, Mr. Chair. My name is Mark Miller. I'm a senior attorney with Pacific Legal Foundation, PLF, which is a nonprofit law firm that specializes in property rights litigation and policy. I've worked for PLF for most of the last 11 years, but I took 3 years off to be South Dakota Governor Kristi Noem's Chief of Staff and General Counsel, where I also focused and testified in legislative committees on land use issues like the bill before you today on squatters. I'm also the co-author of a research and brief paper published last year titled Locking Squatters Out: How States Can Protect Property Owners. Thus, I can offer you insights into the rise in squatting and how states should combat it. Today, I'm before the committee to ask for your vote in favor of the bill. And with that, I'm going to cut my spiel off because I think you all have done a fantastic job of going through it. But I would like to just address some of the questions, hopefully help to resolve them such that the ones that are still remaining outstanding, Mr. Chair, if that works for the committee.
Go ahead.
Okay. So on Senator Crago's point, if I was understanding correctly, he was getting at the holdover issue versus a squatter. And the bill intends to very explicitly separate squatters who are true trespassers from holdovers, and people who had a lease, who were tenants and now have gone month to month or what have you. And I think that in the definitions and then in section 1 of the bill, it intends at least to say this is not the holdover tenant. If we talk about the bundle of sticks that I know the legislators are very familiar with, if you were a tenant, you had a stick in the bundle. A trespasser never had any stick in the bundle of property rights. And this bill is designed, as I understand it, living in Florida as I do and being familiar with the Florida law and other states that have addressed this bill is intended specifically to just treat true trespassers, squatters. Second, to Senator Hicks, who had, I think, 2 excellent questions. One, who has the duty to investigate that the owner is the actual owner? I think the purpose of the bill, as I understand the bill, and Pacific Legal Foundation has a model bill very similar to this bill, which we look to Florida and Georgia as sort of the gold standard, if you will, on squatter bills, having both addressed it last year. Here, I think the effort here is to take responsibility from law enforcement away. The reason why squatters have proliferated or have grown, the reason why squatting has grown as a problem is too often law enforcement does not know how to separate between owners and those who are living there. Are they tenants or not? And so they say you need to go to landlord-tenant court and get an eviction. And that takes time and money. And so here, by forcing the owner to submit a sworn statement, the idea is the law enforcement officer can rely upon the sworn statement and no longer has the responsibility to investigate such that he or she throws her hands up. So that's to your first question. Second question on a reasonable rate. I think Mr. Thompson addressed this, but in terms of the reasonable rate for what law enforcement can charge, I think the property owner who's facing a squatter who could end up staying for months, even years, we've seen in other states, because they fight this out in landlord-tenant court and they do it in a Philadelphia lawyer manner. the property owner will be happy to pay whatever law enforcement says is a reasonable rate, because as Mr. Thompson alluded to, if you're in landlord-tenant court, there's gonna be any sorts of fees, like the writ of possession, law enforcement will have to remove the tenant if the squatter is treated as a tenant, and there are costs that accord there. And so I think that the property owner in this position will be happy to pay a reasonable rate. Then finally, Mr. Thompson brought up that if there's a former tenant and the owner doesn't know, and I think Senator Craig pointed this out in a different context, but I'll just reiterate it. The law wants to be protective of those who actually are being wrongfully removed, and provides that that wrongfully removed tenant, who is not a squatter, has a right of action against the owner, who swears out that this person was not a tenant, but in fact was. So if that property owner is being dishonest and taking advantage of the fact that law enforcement is taking that sworn statement on face value, then that owner will be the one who pays the price, whether it be to the tenant or to law enforcement themselves. Lastly, and I may need clarity on this myself, but there was an overarching sort of ongoing question of proof of ownership. If I understand the bill correctly, and entirely possible I do not, but if I understand it correctly, the owner does not need to prove ownership, like have a deed. Rather, this individual who either represents the owner or is the owner simply has to represent in the affidavit, in the sworn statement, that he or she is the owner or an agent of the owner. Again, at that point, law enforcement can move forward. So to the extent that we're worried about time, the law enforcement presented with the sworn statement should be able to act, whether it's Friday afternoon or the weekend. And so with that, I will stand by for questions.
Questions for Mr. Miller? Yes, Senator Hicks.
Yeah, Mr. Miller, I still question the idea that somehow the property owner who's been paying taxes on this for all those local government services all along is now liable for paying for what law enforcement to enforce the law in this particular case. And so in your experience with these other states, do any of the other states put the financial burden then back on the, let's just call them the unauthorized person, I think is the language, in the language, and what's been the outcome of trying to do that, if there is any?
Mr. Miller?
So and Senator Crago may know better, Mr. Chair, Senator Crago may know better, but if I understand right, that is straight out of the Florida law. And I don't think there have been any concerns with it in Florida. The only of the squatter bills that have been passed and signed into law over the last year, the only issue that has arisen is one case in Georgia where the judge elected not to treat a squatter like a squatter, rather treated them like a tenant, despite a law very similar to this law. And that created a lot of national news attention. By and large, the bill you have before you in Florida, or the version of the bill that you have in front of you, which is quite similar to that Florida bill, has been working very well. And lastly, I should say, Senator, I do appreciate, at Pacific Legal Foundation, we appreciate when the government tries to wring every last penny out of property owners. In fact, that's what we do quite a bit in litigation, is sue when the government tries to exact fees from you that you shouldn't owe. Here, again, I would make that analogy, and I understand it may not be fully persuasive, but that if they end up in landlord-tenant court, in other words, if we don't have this law in place, they're going to end up paying more. And over time, first of all, and then money just to get them evicted. Although I'm not going to oppose efforts to strip that out of the bill. At the same time, having been involved in the legislative process in the past, I worry about death by 1,000 cuts as well. And I think the concern you have is livable, and maybe we can come back another day, another year, and fix it.
All right, thank you, Mr. Miller. Do we have Ms. Glean?
Hi, my name is Julie Glean. I'm with the Landlords Association. We're a statewide nonprofit, but typically we handle mostly Cheyenne. We are very much for this law.
Hey, Julie, is your camera not on intentionally?
Not necessarily. There we go.
There we go, thank you.
Okay, so we are primarily out of Cheyenne. We have over 10,000 rentals. We see this monthly. In Cheyenne alone, there are over 180 evictions a month. One or two of these tend to sometimes have the trespass squatters type issues. Typically, right now, if we call law enforcement, it's always a civil matter. For a landlord to process this through the FEDs, they're looking at a minimum of 21 days. But recently, in the month of December, the FEDs were being set up for hearing as much as 6 weeks after the complaint for forcible entry and detainer was filed. Some of the language we're concerned about is previous tenants. We don't have a problem if it's a holdover tenant. What we have a problem with is a tenant that maybe rented there 5 years ago, they were evicted 5 years ago. Are they still considered a previous tenant? Trespassers and squatters, when we call law enforcement, all they're looking for is, did they have a toothbrush there? Did they have their shoes there? Any of that makes them a tenant. And that clearly is not what the landlords intended. I've also heard about this charge for standbys. We actually have done a non-statutory standby. We've been doing it for a while. Typically, the first 2 hours are the landlords. After the first 2 hours, it is the tenant's responsibility to pay. And how we've done this and told the tenants is, you've got 2 hours to get your stuff out. You're here to get your stuff out. If you don't show up with a vehicle and manpower to get it out, then we're not even going to let you start. And then we remind them that they're not there to eat or shower or reminisce or anything. They have 2 hours. After 2 hours, if they're not done, then they now have to start paying $100 an hour to get their stuff out. It's not really about the money. It's about them getting to business and getting their stuff out. The landlord doesn't want it. They don't want to take care of it. They want the tenant to have their stuff and take it. But then again, they don't want the tenant to take days on days getting their stuff out. And I'll stand for any questions.
Any questions for Ms. Gleam? Yes, Senator Hicks.
Yeah, Mr. Chairman, so on this issue of the, the time frame to get them out and the way the bill's constructed, it's to vacate their property to the property line. And the scenario that you talked about is having trucks to completely get it off, out of any relationship or touching the property at all. So how do you see that comport with what you guys are doing and the way the bill draft is? It says they have to remove it, I believe, to the edge of the property line. And maybe Senator Craigo can answer that question.
Senator Craigo?
Thank you, Mr. Chairman. I actually don't think this bill applies in that particular circumstance, because if you're a current or former tenant, this language does not apply to you. So you're then gonna have to, the landlord, owner of the property, will have to still pursue under the FED statutes, which we already, are already in statute. This is really just, people, I don't think it's not gonna cover that particular situation. Just let me leave it at that.
Any other questions for Ms. Gleam? All right, we thank you for your testimony. Thank you for joining us.
Thank you.
With that, I will close public comment. Senators, what is your pleasure?
Move the bill.
Okay, it's been moved and moved by Senator Craigo and seconded by Senator Kolb. Are there any amendments to this file?
Mr. Chairman,
Yes, Senator Hicks.
so page 8, line 15, this is probably just falls in the arena of clarification. It says unauthorized occupant. The title and everything else through the bill talks about unauthorized persons. And so I would just make the motion that we change from occupant to persons to make the language consisting and conforming all the way through the bill.
And is that the only place where you noticed that?
It's the only place I could find reference to occupant versus persons.
Looks like it's also on page 8, line 8,
So
unauthorized occupant. So your amendment would just be conforming.
conforming throughout the bill, Mr. President, or Chairman.
Wherever the word unauthorized occupant appears, you change it to unauthorized person. Any discussion on that amendment?
Second.
Okay, it was seconded by Senator Crum. All those in favor signify by saying aye.
Aye.
Any opposed? That amendment does carry. Any other amendments to this bill? Yes, Senator
Chairman,
Hicks.
and I'll make the amendment, we maybe have a little discussion, but on the same page, page 8, line 11, after the word "the," where it says "the owner shall pay," I'll just make the motion that we strike the word "owner" and insert "unauthorized persons shall pay to law enforcement."
Okay, and I'm not requiring, just so we're aware, I'm not requiring seconds on motions, so we can discuss that motion. Any discussion on it? Senator Craigo?
Thank you, Mr. Chairman. I would almost rather just take the language out altogether and say no fees being charged. And the reason I say that is we might just create more of an administrative nightmare for our local law enforcement fellas and gals, because now we're saying you need to go recoup this, and it might be $100 and they spend $500 trying to get it. If they end up charging the person with a particular crime, there could be some restitution in that built into the criminal conviction that doesn't even need to be in this statute. It could just be part of, an assessment the judge makes. They could make that argument at that time. The restitution included, a civil standby for 5 hours. We want to be reimbursed for that. I think that'd be cleaner than doing that, because what might happen, they might just throw the person out and that person disappears. They never see him again. And if we say they have to collect a fee, then they have to hold that person and we want them out of town.
Mr. Chairman, I like the direction that this discussion's gone, so I will withdraw my motion, and maybe we can have that discussion, or I can make that motion, but it's actually, I'll just make
Why don't you make that
Senator
motion?
Crago's suggestion that starting on line 9 with the word "when," we strike the balance of that line, balance of line 10, 11, and 12.
Okay, we've had some discussion on that. Any additional discussion? Senator Kolb?
Point out it says may charge a fee. I want to strike.
It does. It is permissive.
So it is, it's a choice. But I just wanted to point that out, Mr. Chairman.
Okay. Any other discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? That amendment is adopted. Any other amendments to this bill?
Mr. Chairman.
Senator Craigo?
At the request of the realtors, and I have a little bit of a mixed emotion about this, but I think in the majority of the cases, it's gonna be better if that language is not in there. I do get that. You and I had a discussion ahead of time. I think, Mr. Thompson, added some color to that, why the language is in there, but I think the majority of the time it'd be better if it was not. I think people, the landowner's gonna get that affidavit. We're gonna have a form created. Every department in Wyoming's gonna hand out a form, and one of the questions you're gonna have to answer before you can sign the affidavit is, when did you acquire the property? And that's just gonna throw a lot of these folks into a tailspin. So I'm gonna move that we delete lines 21 and 22 on page 4.
Okay, discussion on that amendment? Senator Kolb, did you want to discuss that amendment?
I did. So there's backstop.
You want to light up your mic?
Oh, yes. Yes, Mr. Chairman. I'm lit. There's a backstop to this, because if you falsely accuse someone of doing this, there's a consequence for doing that. So I feel comfortable in taking this out.
All right. Senator Craigo?
Yeah, just a little bit of color, just so, because I think we're gonna get this question when we get to the floor, and all 5 of us, so we all know kind of where we are, what we're thinking. I mean, there's situations, for example, let's take an adverse possession case. You go to court, you get an order from the judge saying you now own a piece of property. I'm just throwing this out. This isn't likely, but it's possible, right? So that same day, you then walk down the street, hand this to law enforcement and say, I want so-and-so kicked out of that property. I mean, that was sort of a little bit of information that might help them determine if you've only owned the property for a day, they might be a lot less likely to follow through on this. But like I said, I'm all for taking it out, but I think that question will come up is, how are we gonna prevent that? Because the person is not lying when they sign the affidavit saying they own it. It just might not, the person that's in there may not have a legal right, but the person living in there may not even know they don't have the legal right anymore. So I think that's part of an additional safety mechanism built into the law, but I agree we can take it out.
All right, any other discussion? All those in favor signify by saying aye.
Aye.
Any opposed, no. That amendment does carry. Are there any other amendments to this bill? All right. Let's do a roll call vote on Senate File 6.
Aye.
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 Aye. And who wants to floor manage it? I wonder who that could be. Senator Craigo.
Yes, Mr. Chairman. The co-chair.
And earn your vice chair stripes.
Thank you.
All right, the next file for our consideration is Senate File 11, Use of Fraudulent Documents to Wrongfully Possess Property. This is also a bill from our Joint Judiciary Interim Committee. This bill goes along hand in hand with the bill we just talked about. Creates a new statute, 6-3-616, the use of fraudulent documents to gain or remain in possession of property. And what it does is create a felony provision, which is punishable by up to 10 years or a fine of $10,000 or both if a person intentionally uses a document that the person knows or reasonably should know is false or fraudulent, and they use it to gain or remain in possession of property, or they use it to claim a right to property for which the person does not have a legal right to possess or claim a right. And this is effective July 1st, 2025. Senator.
If I may, I have a bill up on Senate Appropriations that was a select capital finance bill that I worked 2 years on, and would like to make sure that we get it through there's, if you may, I'm gonna leave a proxy on it.
That sounds good. Yep.
Thank you.
Good luck. Public testimony on this bill. Do we have any state agencies that want to testify on this bill? Do we have anyone who's not a state agency who wants to testify on this bill? The realtors. Ms. Urbakite, welcome back.
Thank you, Mr. Chairman. Lori Urbakite with Wyoming Realtors. I'm going to be even quicker than Mr. Moline.
All right.
We are very supportive of this bill and urge your adoption. We think it does go hand in hand with the previous bill.
Senator Craigo, was there a reason why this wasn't part of the original, why they weren't just in one bill? Was it separated on purpose? Or did the ideas just come separately?
Mr. Chairman, to be honest, I can't remember exactly how that all went down. I think they were sort of two different options for solving the problem. I don't think, to be honest with you, I don't know if we need both of them. Do I mind this bill? No, I mean, I'm also in support of the bill, but I don't know if we need it, if we pass the other legislation. And I think part of it is the other one's much more complicated. This one's very simple, straightforward. And so, I mean, in fact, you could take, if you really are intent on this language, it could be added, into the other bill rather than running to. So I don't remember why or how it ended up that way. I'm sure we can ask the good chairman when we get upstairs why that was. I can't remember exactly. I know there was a conversation, and to be honest, I missed our first meeting when we had this discussion, and during the interim, I was out of state, so.
Okay. I mean, it is a little different. This is falsifying a document, not just being inside of the property, but taking it to the next step of falsifying a lease or a deed.
That is true. It is, the language is different. It was aimed at the same problem, though. This was all talking about squatters and personal, property rights, real property rights, and making sure we're protecting our landowners and our landlords.
Mr. Chairman.
Ms. Erba-Kite?
I really hate to keep going on, but I think one of the issues with this and the reason it was separated, this is not only are the squatters providing the false documents, but there are entities, and it's happening all across the country, where they are claiming that they own a property, listing it online as for rent. Tenants or people that do not know any better are renting the property, and therein lies, I mean, so that has nothing to do with unauthorized persons or squatters. It is about people falsifying their actual documents, claiming they own a property when they do not.
Right. Senator Prego?
Yeah, and not really a question for the good witness, but actually the false advertising is in the other bill we just passed out. I mean, it's very particular on, that exact issue. This one's a little bit different, and I don't know if that actually falls into this particular category or how this is written, but it does definitely fall in the language on the bill we just passed.
Okay. Thank you, Mr. Erba-Kite. Mr. Thompson? How does law enforcement feel about this one?
Mr. Chairman, Alan Thompson with Westcop. This is a much simpler bill and easier to understand. And I, to the extent that it might conflict with the other bill, I think that we have some strong support for this. There has been some times where fraud and forgery may or may not fit exactly. This outlines that specific crime, makes it easy to follow by law enforcement, helps direct an investigation to find the information that you need to prove it. And so as a standalone bill, I think this is a pretty helpful one from a law enforcement standpoint.
Off the top of your head, do you know what the forgery statute has for a penalty?
Mr. Chairman, I do not. I can look it up.
I'm just trying to make sure I understand the distinction when I go to the floor. Because that is an obvious question, is why, why they couldn't, and we'd have to look up the elements of the crime as well, but we can look it up.
Okay.
No big deal. Any other questions for Mr. Thompson? All right, thank you. Other testimony, Mr. Meyer? The bankers want to rule in.
Thank you, Mr. Chairman, members of the committee. Scott Meyer on behalf of the Wyoming Bankers Association. It's our understanding when we look at this for the two separate bills is that the second one, the one that we're working with right now, is more designed to talk about those, maybe not squatters or anything, but those that just try to assume ownership of a property if they could, and then turn around and either borrow against it, could be selling it, but I'm looking at it more from the standpoint of submitting some kind of a deed to a lender and saying, I'd like to have a mortgage on this property. Now, clearly, a title company may look at this and say, we got a little bit of a problem here, but but my understanding is why we have the two separate bills. And we would certainly stand in favor of this bill.
Questions?
Stand for any questions.
Questions for Mr. Meyer? All right, thank you.
Thank you.
Other testimony. Online, we have Ms. Gleam again. Okay. She declined. Okay. Then is there any other testimony online? All right, I will close public testimony. Senators, what is your pleasure?
Move the bill.
It's been moved by Senator Kolb,
Second.
seconded by Senator Crum. Are there any amendments to this bill? All right. Any discussion on this bill? Senator Kolb?
Yeah, thank you, Mr. Chairman. I see them as being two different things, and I think maybe with a little bit of research about the elements of crime of forgery will give us a clear direction here, but I see them both needed. The
Yeah.
second bill needed. Thank you, Mr.
I
Chairman.
think we're definitely gonna have to look that up, because experience tells me that will be a question from, at some point that we're gonna face, is why forgery is not sufficient enough of a crime. And with that, let's go ahead and take a roll call vote on Senate File 11, use of fraudulent documents to wrongfully possess property.
Senator Craigo,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Here, aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye,
That's 5 ayes.
excellent. Senator Kolb, would you like to present this bill to the floor?
I would.
All right, thank you. Since you spoke, since you spoke on it, that's why I called on you. See how that works?
My penalty?
Yep.
Chairman?
All right, the next two files that we have deal with protection orders. The first is Senate File 7, Protection Order Amendments. And Senator Craigo, do you have any comments from the interim committee that you want to?
Not
brief us on
necessarily,
this?
we might just get our good,
Supreme Court?
yes, or
Okay.
the department up.
Or, oh, yeah, you're hiding back there in the back. Yep. So both of you can come up, actually. All right. Walk us through this bill.
Mr. Chairman, members of the committee, my name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. This was a bill that originated with us, with the Judicial Branch, and really it was aimed toward making the process a little bit easier for our courts and our clerks. So just a little bit of background. In Wyoming, we have 3 different kinds of protection orders: sexual assault, stalking, and domestic violence protection orders. Sexual assault and stalking both live in Title VII of the statutes. The domestic violence protection order statutes live in Title 35. So what we tried to do here, a couple of different things, is initially we tried to marry up the language between the 2 different kinds of statutes. So Title VII is pretty consistent between stalking and sexual assault because they live in the same title. Title 35 has a lot of different language. So much of the language that you see in this bill really is aimed at trying to make those statutes consistent. And then there are a few process things that our clerks struggle with pretty consistently in terms of just how the process of those protection orders operate. And so there's some cleanup there. And Mr. Chairman, I'd be happy to walk you through the bill if you'd like. Each page or however you'd like me to proceed.
Cool. Yes, Ms. Butler, let's just go through page by page.
So, Mr. Chairman, starting on page 2, you will see a change in 73506 on the definition of court. And what this does is, first of all, it mirrors language for victims and perpetrators. So it really does define the jurisdiction of a circuit court within a certain venue. And so you'll see that we have the committee added language on line 10 where it says the alleged victim of stalking or sexual assault resides or is found. So the petitioner can bring the action either where they reside or where they are found. So even if they do not reside in a county, they would be able to bring a protection order there. And that mirrors a little bit the language of where the alleged perpetrator of stalking or sexual assault resides or is found. So just expands that a little bit and then adds the language of where an act of stalking or sexual assault occurred. Often you may have a victim or a perpetrator in a location where where the actual incidents are occurring. That is where the evidence lives. And so most often that may be the most appropriate court to bring that action in. And so that's the language there that defines the jurisdiction of the court in lines 8 through 12 on page 2. And Mr. Chairman, moving on, you'll see a bit of just a language change on page 9 or on line 19. And then if you move on, this is where we had starting on
That
line.
is preferred to which?
Yeah, apparently.
Glad we caught that one.
Yes. Moving on page 2, starting on line 23 and onto page 3. What you'll find is some language change there about appointing attorneys for a victim. So what has happened historically is the language is pretty broad and allows the court to appoint an attorney for a victim in any circumstance. What we have seen in the courts is that sometimes creates an expectation for victims that they are going to get an attorney. That's not always the case. And quite frankly, the judicial branch doesn't have any funding attached to this. So even if a court appoints an attorney, there's no funding within the branch to pay that attorney. And so there was a lot of discussion in the committee about how to refine this and how to narrow that down. And what the committee ultimately came to is that limiting that ability to appoint an attorney to a victim who is under the age of 21. And so that's the language that you find on line 23 on page 2 and into page 3 through line 4.
Why is it 21 versus 18? Yeah,
Mr. Chairman.
that's everybody's question.
It is a very good question. There was a lot of discussion about this in committees, so I don't know if Senator Crago would like to jump in, but there was a lot of discussion about whether age is a good deciding factor. There are folks who are going to be 19 who potentially really could use an attorney, and so that was the discussion in the committee. 21 narrows it, but doesn't narrow it so drastically that someone who needs an attorney can't get one, I think was the discussion there.
Okay, Senator Crago?
That's exactly right. I mean, that was the discussion that was had is originally at one point we did have 18 in there and everybody said, well, we feel like that's limiting it too much. So we want to give the court a little bit of discretion, but not leave it as wide open as it has been. And so that was sort of the number we settled on. There's no science in it. It was just something what I think everybody thought was a fair place to land.
Okay.
Mr. Chairman, moving on to 73508, you'll find two changes on lines 11 and 12 on page 3 and then line 18 on page 3. It extends the hearing date for a petition from 72 hours to 10 days. The reason for this really is a process issue, and that is quite often what we run into in the courts is we're not able to serve somebody within 3 days. And so what happens is those hearings get reset and reset and reset until service is actually perfected. So this provides just a little bit of leeway for the setting of that hearing and service to occur before the hearing. There will, if service is perfected sooner than 10 days, there's a very real possibility that that hearing would be set sooner than 10 days, but that's what we run into pretty consistently in our circuit courts.
And so what's happening here is there's a temporary order put in place, an ex parte order that's put in place, and then what we're really talking about is the accused's access to challenge that temporary order.
Mr. Chairman, potentially. So there are two different things that could happen when a victim petitions for a protection order. The court can issue an ex parte protection order, or if it determines that that's not warranted at the time, it can not. But there still has to be a hearing either way. And so this 10-day period is the time that is set for that hearing on the protection order, whether an ex parte is issued or not, if that makes sense.
So if service is the issue, could we fine tune the language so that it says that if their service is perfected, that the hearing be set sooner? 10 days seem, I mean, 70 from a 72-hour jump to 10 days, that's a really big jump.
Mr. Chairman, I mean, you could. I think the issue that we run into is when the courts are setting the hearing when they receive that petition, right? So when the clerk gets the petition, they will look at the calendar, and because it's required to be set in 3 days right now, they'll go ahead and they'll set the hearing within 3 days. That means the court's docket is not available for whatever time that hearing is set. And so if you add in the language that, they'll do it whenever service is perfected, it takes out some of that consistency. It doesn't mean that we can't, but the hearing is set when the petition is filed.
Okay. Senator Cole?
Thank you, Mr. Chairman. Was it arbitrary to come up with 10 days? I mean, what was the time? I mean, you had 72 hours in the past, and now all of a sudden we go from one, I guess, extreme to the other. How did you arrive upon 10 days? And why wasn't 5 days considered? I mean, how did we get to 10, from 72 to 10? Could you tell me that process?
Ms. Butler?
Mr. Chairman, Senator Cole, but it was anecdotal from the courts and the judges and the clerks who work in those systems, and based on their experience, the 10 days was what we suggested, just based on when they are able to schedule those hearings and service occurs.
Hey, Kylie, would you do me a favor? Could you close that door? Any other questions on the 10-day provision? All right, I still have a little heartburn over it, but I understand what we're trying to do.
Mr. Chairman, moving into 73510, which begins on page 3 and extends into page 4. What you'll find is some strikeouts starting on page 2, and then new language on line 4 through 11. That language mirrors language that we have in Title 35. So essentially what it says is when a protection order is granted, that protection order is going to be filed with the clerk of court, which is something that happens in all cases. And that the clerk is responsible for sending a copy to the sheriff. The sheriff will serve that, and after service, the sheriff is required to notify the local law enforcement agency within the county where the petitioner resides. So as we talked about before, it's very possible that the petitioner may not reside in the county where the protection order is issued. So it's just a safeguard to make sure that the law enforcement in the county where the petitioner resides know that there's a protection order out there. And then it also adds some language in there about personal service. So the sheriff is required to personally serve, but it accepts from that personal service requirement if the respondent or the respondent's attorney is present at the hearing, or present in person at the hearing, or present remotely. And again, this is just one of the things that I think we run into quite often, which is service is hard. And so if you're at the hearing, you've received notice that there's a protection order against you.
All right, please proceed.
Mr. Chairman, moving on into subsection B, you'll see that I think this was an LSO change on line 16 to break these subsections out because they deal with different things. But Romanet 1 on line 23, you'll see a change. It talks about, so this section talks about what happens when a protection order changes. So when it's modified, when it's extended, when it terminates. And again, we're talking about service here and how is that served. And the language here says that when there's an extension, a modification, or a termination, it's served upon the respondent by mailing the order to the last known address of the respondent that's on file with the clerk. So one of the things that's required of respondents when an original protection order is issued is that they are required to be accountable to the court and to update their address with the court. And if the respondent fails to do that, they become very difficult to find. And so this perfects service based on what the respondent has provided to the court. So if the last known address that the respondent is accountable for is with the clerk and it's incorrect, that's the respondent's responsibility. And so perfect service for an extension, termination, or modification upon mailing to the last known address of the respondent.
Was there any discussion about certified mail, or why, regular mail seems a lot more lenient? So I can understand why as a court mailing it out, you might want that, or as a clerk mailing it out. But as the person on the other end receiving it, I might want it to be certified.
Mr. Chairman, I don't recall a discussion about certified mail. In fact, I don't recall much discussion on this provision, but I could be wrong.
Senator Craigo?
I do not remember any discussion. I don't think it has to be, I mean, I guess this would be a good question for either of the two ladies, whether, I mean, the order itself, I don't think has to, the renewal order, I don't think it has to be served in any particular manner now. I think it was just clarifying that. The original one does, and then the notice of the hearing where the judge would hear the request for renewal would have to be served upon somehow the respondent would have to be noticed of that, but I don't know about the order, I guess. I don't know the process on the back end of that.
Okay,
Mr. Chairman,
yes.
if I may, and I think right now, those extensions, terminations, modifications, I believe they are being served through the sheriff's office generally.
Got it.
All right, Mr. Chairman, I'll try to be quick about the rest of it because most of what you will see in the remaining pages, well, there's a small change again on page 5. That's a language change from LSO. But in the remaining pages, starting on page 5, line 19, and through the end, most of these are mirror amendments. So we're now in Title 35, which is the Domestic Relations Protection Order section. And so most of these changes within this last portion are to mirror either the language that exists today within Title VII or language that the committee approved as an amendment in Title VII. And so this language just, again, tries to marry up those two different places where we have protection order statutes, so we have more consistency in all of our protection orders. Mr. Chairman, I'd be happy to walk through each one of those if you'd like, but
You said all are.
Mr.
Conforming language between the statutes.
Ms.
Those are the
Butler?
ones I'm most interested in.
Okay, Ms. Butler?
Mr. Chairman, Senator Hicks, the one place that I think I would point out that is, you will see that is different, so not included in this bill draft, and that's on line 6, or page 6, I'm sorry, starting in line 12. And so what you'll see is this changes in the domestic violence protection orders, who is allowed to petition for a protection order, and it expands that right to different entities or different people. And this does mirror Title VII. It's just not an amendment that you're gonna see in this bill draft because it already exists in Title VII. So that language currently exists in Title VII. It allows more than just the victim to petition for a sexual assault or a stalking protection order. That language historically has not existed in the domestic violence protection order, so it just adds that language in here. And I think, Mr. Chairman, just looking through to make sure I'm correct, the rest of these, I believe, are amendments that you'll see in the bill in Title VII. And then on page 10, you'll see section 2 just clarifies that the changes to these protection order statutes will apply to future petitions, not to any existing petitions for protection orders, starting on July 1st of 25.
Questions for Ms. Butler? All right, anything else to add?
Mr. Chairman, no, thank you.
All right. Thank you for walking us through the bill. It's very helpful. Having not been on the interim committee and seeing it for the first time, I really appreciate that. Any other public testimony on this bill? All right, online we do have some testimony. We have a Sandy Stevens, an Yvonne Swanson, and an Amy Hefner. Okay, go ahead and let them both in. And we'll see who gets here first. Yvonne Swanson, you're up. Hello,
Hello, can you hear me?
we sure can.
Hi, thank you, Mr. Chairman. Thank you for this opportunity. This is my first time testifying, so a little scared. But my name is Yvonne Swanson. I'm with the Advocacy and Resource Center in Sheridan County. Our agency is an agency that provides services to all violent crime victims in our county. But I definitely want to point out that our services to domestic violence, sexual assault, and stalking victims are not limited to emergency shelter, food, and other necessities and relocation assistance. We provide criminal justice and law enforcement advocacy. With all of that, I have 5 advocates that assist with protection orders, which includes accompanying them to hearing, safety planning, and financial assistance with rehoming our victims to have a safe place to live. I appreciated the testimony before me because I wasn't available and didn't see the beginning and the making of the bill. But I do want to point out that I've been providing services for victims for 19 years. And although I can appreciate what the courts are going through with the hearing and the scheduling, I want to point out on how dangerous it is for our victims when they file a protection order and how long the 72-hour wait already feels when we have victims calling our crisis line and they're asking for an emergency protection order that we don't have. And so trying to explain to a victim that you're going to fill out a protection order and now we have a 10-day wait, it causes a lot of concern for me. If we could have ex parte orders issued every time a domestic violence victim were to ask for a protection order, it would ease our hearts a little bit and our money, and our safety planning would look a little different, but we can't be guaranteed that. We've never been guaranteed that. So that's a huge concern for us as advocates working with victims. Because when somebody decides to file a protection order and get out of a bad situation and their offender finds out that they are doing that, the threat increase is substantial for themselves and their children. I did want to also talk about the financial burden. In 2024, the Advocacy and Resource Center assisted with 40 family violence protection orders. If I potentially have to put one victim and her family in shelter for 10 days awaiting a protection order hearing, and we pay, because I don't have a shelter in Sheridan County, $100 a night, there's a potential of like $40,000 of emergency assistance that I might have to find. Currently, my budget for emergency financial assistance is $35,000. And with that $35,000, I'm already assisting people getting into new homes. I'm paying for rent, clothing, food, relocation expenses, transportation out of town for the safety reasons. And I'm still trying to pay my employees a livable wage. So that causes burden not just on victims for their safety, but also agencies like mine to figure out how do we help a victim who's fleeing violence for 10 days to have a protection order hearing. If there was an ex parte issued, law enforcement can help remove the respondent from the home and the victim would have access to their own home. Not all the time is that feasible. Sometimes the victims don't want to be back in that house, but an ex parte order in place would definitely solve some of those issues that we have. So I just reiterate that the 10-day time frame not only puts victims' safety at jeopardy, which is the whole point of a protection order. It also puts a burden on our communities and our social agencies that financially assist victims in that transition. Victims come to our agencies as a last resort and they file for protection orders. as a last resort, hoping to be heard and to find safety. So by increasing that time frame in which the judicial system must take action by, allowing that additional 7-day time period, is almost as if we're telling the victims that we serve that their emotional and physical safety has dropped from the top of our priority list. I urge you to oppose this amendment and give victims in our community peace of mind in knowing that these systems that are put into place to protect them are working the way that they can be. So that's what I've got. Thank you so much for your time.
Thank you. We'll see if we have any questions for you, Senator Craigo.
Thank you, Mr. Chairman, and thanks for being with us today. So just a quick question on the bill, generally speaking. Are you against all of the changes we're making with, or proposed changes we're making within the bill, or just the 72-hour to 10-day portion?
Ms.
Yes,
Swanson?
Mr. Chairman, it's mostly that 10 days, especially if there's not an ex parte in order. Because there are several times when they have filed a protection order or a stalking protection order, people are showing up for immediate relief. They're asking for help right away. And if there isn't an ex parte order that provides that emergency relief until there's a hearing, it does put them in jeopardy of safety. And that's a concern for me.
Mr. Chairman,
Senator Crum?
question, if the extension would move from 72 hours to 10 days and heard about additional funding, where would that additional funding come from? Do you have any idea on that?
I don't know. The Advocacy and Resource Center receives a little over 50% of our funding from state and federal funding. We have an amazing community in Sheridan, and I do a lot of my own private fundraising and foundations and things like that, but that's where we'd have to work.
Mr. Chairman, that's a fair
Senator
answer.
Crum?
Thank you.
Okay. Any other questions? All right, Ms. Swanson, we do appreciate your testimony. Thank you.
Thank you.
Oh, wait, we got one more question. Senator Hicks.
Yeah, I'm just curious if you'd opine on changing this now to only those folks under 21 years old, and in your experience with the people that you deal with, does that capture 50% of the population, or just a rough estimate based on your experience? How many would now qualify if we leave this language in that basically says the victim is under the age of 21? How much would that reduce your workload, and then those other folks that are now not going to be the recipient of this? Would you like to opine on that?
Sure, Mr. Chairman. Unfortunately, I can't really speak on that. In Sheridan County, I have never seen our judges appoint an attorney for any victim. So when we help or assist a victim and they're asking us, what does this line item mean on our protection order? We gracefully skip ahead of that because it's never been something that's ever been granted in Sheridan County that I'm aware of.
All right, Senator Craigo's agreeing. Any other questions? Thank you, Ms. Swanson.
Thank you for your time.
Ms. Hefner Klein. Okay, well, we'll go ahead and close public comment. We have about 5 minutes before we have to be to our next location committee. We can dispose of this bill, work through this bill. Let me just ask, does anyone have any amendments to this bill? So I can understand how much time we need to work it. Yes, yes.
I would have three, but they're very quick. I think it wouldn't take long to discuss.
Okay.
I got three, but my guess is they're probably very similar to some of the.
All right, so maybe it won't. Let's start working on the bill and just see where we get in the next couple of minutes. Senator Crum?
Okay, the three that I would have, and maybe we can do it all under one motion, is, again.
Oh, sorry, is there a motion to move this bill?
I'll make the motion to move the bill.
Moved by Senator Colvin, seconded by Senator Crum. Go ahead, Senator Crum.
Would be on line, or page 3, line 1, I would recommend changing that date to 18. That's the age of majority. It seems to be what would make sense to me. Then I would change on line 3, page 18, 10 days and leave this to 72
Let's
hours.
take them one at a time, because they
Oh,
are,
you want to do it one at a
they're
time?
substantively different, so yes.
Okay, and then,
So-
so line,
We'll just take the
one,
first.
page 3, and then
Yep.
it would be consistent with that would be on line 11 on page 8. Would be, or I'm sorry, not, that's the wrong line. Page 7, line 19, again, 21 to 18.
Okay. We've got that discussion on that amendment.
Mr. Chairman?
Senator Hicks?
Yeah, that was, initially, Mr. Chairman, that's kind of where I was going, but the more I look at this, my preference would be is just a language and reinstate the old language, except for that on line 2, and would be to leave that in. So my first inclination was to make it the age of majority of 18, but I still worry about the folks that can't afford an attorney that may need a court, that are over 18 years old. The 18 and a half-year-old, or the 19-year-old, or the 20-year-old. And so I think we have a duty to provide equal justice to all folks. And I guess, so conceptually, I was for the direction you're going, but I guess I'll have to vote against that. If it fails, it would bring back my own motion on that provision.
Mr. Chairman?
Senator Crowe?
My only thought, and I don't disagree with Mr. Hicks on, we want to provide equal protection, but where do you draw the line? I mean, is it 21 now, is it 24, is it 25? You know, where do we draw the line? And to me, a place to draw the line would be at the age of majority 18.
Yeah, Mr. Chairman, if I may respond.
Yes, Senator Hicks.
Currently, we have no line. It's everybody. So,
Yes, sir.
Senator Craigo?
I mean, when I said there was no science on the age of 21, it is an age that's used in a lot of other places, which is why I think we landed there. I mean, it's not technically applicable to this particular situation, but I believe that's why we landed there, because in other areas of the law, 21 is used as a dividing line. And so we felt 18 was too limiting, and you're gonna get a lot of folks that are 19, as you mentioned. And so I think we thought, I mean, if we're gonna limit it at all, we did not want to go to 18, so I would either suggest we leave it at 21 or go back to the language that's in there now, which doesn't necessarily help our courts solve their problem, but I think it'd be better than going to 18, so I'm also against the present motion.
All right. I think we know where this motion's going. All those in favor signify by saying aye.
I'm going to go against it, so
That's an aye.
you swayed me.
All right, all those opposed to this motion? No, yeah, okay, that motion has failed. All right, Senator Crum, you had another amendment to the 10-day provision?
Yes, on line 18, page 3, from 10, take it back to 72 hours. I just think that waiting period, oh, it's in a couple places there. On plain page 3, line 11 and 12.
All right. Any discussion on this amendment? Senator Kolb?
Thank you, Mr. Chairman. In the bill title, it says extending the time set, so it's in the bill title. Can we change that, take that out of there?
Yeah, we would just, yep, we would need to amend the bill title as well.
Yeah, that's what, okay, I'm good with the amendment, but I just wanted to point that out.
Good, thank you. So that's line 3, extending the time to set a hearing on a petition through line 4. That would be stricken in this amendment as well.
Mr. Chairman, just to make sure we're catching the amendments on page 8 as well.
Page 8?
I mean, it's just the mirror amendments in Title 35 versus Title 7, but if we're gonna do one, we've gotta do the other.
Page 8, line 11, okay. And line 19, 18, 19. Got it. LSO, you got it? All right, any other discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? That amendment does carry. Any other amendments to this bill?
Mr. Chairman,
Yes.
if my colleague doesn't have any more,
That's it for Senator Crum. Senator Hicks, go ahead.
I'll just pick up your amendment for you, Mr. Chairman, because I was thinking the same thing on page 5.
Yes.
Line 2, respond by insert certified mail. And then the same thing as the conforming when you get to, I believe, where is that little thing? On page 9, line 22, after by, insert certified mailing.
All right, any other discussion on this amendment? All those in, Senator Craigo.
Just a question, because this is gonna come up when we come to the floor. What happens if they don't accept the certified mailing? So other mailing is considered served upon. If we're in the legal business, it's
Mailbox rule.
But certified has a different rule, right? The mailbox rule may or may not apply, and I think there could be an argument, well, I never got that, and the statute says I have to be served with certified mail. And I know lots of people, and you do too, in your line of business, that refuse certified mail.
Sure.
So I don't know. I guess I'm probably getting against the amendment, I'm not against if we can figure out some solution to change the language later on the floor and our multiple readings, but I think that causes us more problems than it solves, because lots of people literally will not pick up that. And unless we, explicitly spell out in this language that sending it certified mail, whether received or not, constitutes service, I don't want to only insert the word certified.
Mr. Chairman?
Senator Crum.
In my past, a lot of times we dealt with very similar situations on getting things certified, and what the standard practice was you would send a regular letter and certified, then you would have, you sent it, but then you also had the record, the documentation that, you had something come back they didn't accept, but you had also met that service requirement through the regular mail. So maybe there's a way to do both.
Mr.
Senator
Chairman,
Hicks.
I'm assuming that was a friendly amendment by Senator Crum, that would include regular mail and certified mail, and I think there's a lot of wisdom in doing that. The beauty of certified is that person actually resides there if they accept it, so there's no doubt that that was their address and they
Right.
received it. So I guess I would accept that as a friendly amendment that would now read that it would be by mail and also certified mail.
Okay. The end result is regular mail is the same as sending it certified and regular, I think. You don't really gain anything by having it sent certified in that scenario.
Mr. Chairman, a belt and suspenders.
Belt and suspenders, okay. All right, all those in favor signify by saying aye.
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 Any opposed? That amendment does carry.
Mr. Chairman.
Yes.
Staff has a question.
Staff.
Could you read that amendment again, just to make sure I cut the language?
Sure, page 5, line 2, strike, well, how does this read?
Mr. Chairman, I'll
By
throw something out.
Yeah, go ahead.
Served, so we'll start with the end of the sentence. Say served upon the respondent by certified
Okay.
and regular mail. I don't know that regular's the right word.
This is first-class mail,
First, yeah,
is regular mail.
so it would read respondent by certified and first class.
Thank you.
And that would be conforming with the other location,
Yes,
which was on page 9,
yes,
line 22.
thank you.
Any other amendments?
Mr. Chairman, I'm just gonna throw this one out there, it's back to the victim age and stuff. My amendment would be to reinstate the stricken language on page 2, line 22. Reinstate the stricken language on page 2, line 23. Strike all the new language in that line. Strike on page 3, line 1, strike the new language there. That's my amendment.
Okay, is everyone following?
Would you mind restating the amendment, please?
Senator Hicks, can you restate the amendment?
So, okay, Mr. Chairman, if we go to page 2,
Yep.
line 22, reinstate all the stricken language. Line 23, reinstate all the stricken language and eliminate the new language. That carries over to page 3, line 1, would be to strike all new language. And that's the amendment.
Would you not, and you're not oh my goodness. You're not reinserting indigent petitioner.
No, I'm not.
You're just leaving it open to anyone, period.
Victim of the action. And so all that stays as is in the draft bill.
Okay.
Or in the bill.
Pierre, does that make sense?
Yes.
All right. Senator Craigo?
So there's also, we also would need to do some sort of conforming amendment on page 7, bottom of page 7. It's not the exact same language. It was drafted so it looked similar, but it's not exactly the same. So I think you're gonna have to, we'll have to just work with LSO to do a conforming amendment on that page as well. And then while I have you on the line, Mr. Chairman, I think on page 9, when we did the last amendment regarding service of mail, by mail, on page 5, we also need to do a conforming amendment on pages 9 and 10.
Yep.
To do the same thing.
Did you get that? We won't
Yeah.
work through it, but yeah, make it conforming on 9 and 10. Okay? For the amendment at hand, any other discussion on it? Discussion? All those in favor signify by saying aye.
Aye.
All those opposed?
No.
That amendment does carry. Any other amendments? We have a meeting to go to, so let's do a roll call vote on Senate File 7.
Senator Craigo,
Aye. Aye.
Senator Crum,
Aye.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Senator, Chairman Olson.
Aye.
5 ayes.
All right, and we will take up Senate File 8 at our next meeting, which will be next Tuesday. Thank you.
Mr. Chairman, I will not be here. I will be in Washington, DC.
We'll miss you.
Probably not that much.
Are we adjourned?
We are adjourned.
That's right. I'll take small, I'll take small, thanks.
Yeah, I'm gonna